Good afternoon, everyone. Welcome to the third session of the second day of the Delhi Arbitration Weekend. If I can request the chair, Honorable Chair and the panelists to please grace the dais. Welcome, everyone. It's an unenviable task to gather everyone's attention for a session just after a sumptuous lunch, but the eminent panel that we have today offsets that effect completely. The third session today, session topic is Modern Boundaries of Investment Treaty Arbitration. Just to briefly introduce the topic, the signing of investment treaties have recently gained importance in contemporary economics in order to encourage foreign investment, advance economic well-being, and maintaining international ties. This session discusses how the investment treaty arbitration provides procedural remedies for foreign investors to enforce investor protections contained within specific investment treaties and further discusses the limitations and drawbacks thereto. We have an eminent panel today with us to discuss the same. It is my absolute pleasure to introduce the chair of the session, Honorable Justice P.S. Narasimha, Judge, Supreme Court of India. Justice Narasimha is a judge of the Supreme Court of India since 2021. He was designated as senior advocate by the full court of the Supreme Court of India in the year 2008. He was appointed as the Additional Solicitor General of India in 2014. During that time, he assisted the court in several landmark cases, including the NJAC case before the Constitution Bench. Justice Narasimha was part of the Indian Supreme Court delegation to the Canadian Supreme Court, where he presented a paper on extradition and the environment. He led the Indian team and represented India before the International Tribunal of the Law of Sea, Hamburg, Germany. Furthermore, he has also represented India before the Permanent Court of Arbitration, Hague, in the investment treaty arbitration. During his tenure as senior advocate, Justice Narasimha played a key role in many crucial cases, most notable among them being the BCCI matter and the Ayodhya land dispute. In the BCCI matter, Justice Narasimha was not only an amicus, but later on, he was also appointed as a mediator, and in all matters relating to the BCCI pending before the Supreme Court. He successfully mediated between the members and the board for holding elections and the constitution of an elected body. He is closely associated with the Mediation and Conciliation Project Committee of the Supreme Court of India. We thank you for gracing the dais, sir. We also have on the dais Honorable Justice Devan Ramachandran, Judge, High Court of Kerala. Justice Ramachandran is the present sitting judge of the Kerala High Court since 2018. He was designated as senior advocate by the High Court of Kerala in 2015. Later on, he was sworn in as an additional judge of the High Court. Justice Ramachandran started practicing as an advocate in 1991 and also served as a standing counsel for the CBSE, various public sector banks, and private companies. He has also been appointed as amicus by the High Courts of Kerala in the public interest area relating to the issue of child trafficking from North India to Kerala. In recognition of his eminence, the Kerala High Court engaged him to be its advocate/counsel, when he was just 35 years, making him one of the youngest to do so. His notable cases include initiating a suo motu case on the electrocution of a pedestrian, granting additional compensation by involving the lost title principle. Some of his actions outside the court have also attracted public praise. Notably, in 2022, after waterlogging jammed Kochi, he commuted to the court using the Kochi Metro Rail. We welcome you, sir. He is joined by senior advocate Gourab Banerji. Mr. Gourab Banerji is a senior advocate based in New Delhi and practices mainly in the Honorable Supreme Court in commercial arbitration law, both domestic and international. He was the former Additional Solicitor General of India from 2009 to 2014. In that capacity, he represented the Government of India in popular cases of including Republic of Italy versus Union of India, which is popularly known as the Italian marine cases, and successfully represented the government in persuading the court to hold that India had concurrent jurisdiction to prosecute Italian marines accused of shooting Indian fishermen. After stepping down as the Additional Solicitor General of India in 2014, he joined the Essex Court Chambers as an overseas advocate and is presently associated with them. Some of his landmark cases pertaining to the Indian arbitration in which Mr. Banerji has appeared includes Patel Engineering, Venture Global Engineering, Satyam Computers, Centrotrade Metals, amongst others. Recently, he has been appointed as an amicus by the Supreme Court of India in a Constitution Bench case, that is NN Global Mercantile, dealing with the validity of the arbitration agreement embedded in unstamped contracts. Last but by no means the least, Professor Doug Jones. Professor Jones is a leading international commercial arbitrator and investor state arbitrator as an international judge of the Singapore International Commercial Court. Professor Jones completed his bachelor's and master's from the University of Queensland and was thereafter graded as a graded arbitrator and foundation fellow by the Institute of Arbitrators and Mediators in Australia in 1985. He was then also graded as a chartered arbitrator and companion from the Chartered Institute of Arbitrators in 2007. Professor Jones was appointed as an international judge of the Singapore International Commercial Court in 2019. Professor Jones has experience in both ad hoc and institutional commercial arbitration and has published and spoken extensively in this area. It is not possible for me to enlist all the hats that he dons, so I'll restrict it to the prominent few. In January 1999, Professor Jones was made a member of the Order of Australia in recognition of his 30 years contribution to construction law and dispute resolution. In June 2012, on the Queen's birthday honours list, Doug Jones was made an officer of the Order of Australia for distinguished service to the law as a leader of the areas of arbitration and alternative dispute resolution to policy reform, as well as to national and international professional organizations. In 2020, Professor Jones was elected an honorary bencher of the Hon'ble Society of Gray's Inn. Professor Jones holds numerous awards and recognition in the name, and recently in 2022, the Who's Who Legal 2022 recognized him as the Construction Lawyer of the Year. A round of applause for the Honorable Chair and the panelists, please. Without much further ado, I hand over the reins of the session to Honorable Chair Justice Narasimha, please.
Thank you very much. I must commence with congratulating the International Arbitration Center, the Honorable Chief Justice and his companion judges for organizing this event. And I think the way it is organized is really extraordinary, and it's going to be a turning point in the way we are going to conduct our seminars hereinafter. And I think the Supreme Court and all the high courts will emulate this method of conducting a conference, which I really appreciate. I welcome Justice Devan Ramachandran, Judge of the Kerala High Court, Mr. Gourab Banerji, Learned Senior Counsel, former Additional Solicitor General, and Professor Jones, eminent personality, expert in the field, is with us. The topic of the day, the modern boundaries of investment treaty arbitration, unlike other sessions, is a little different, in the sense that we are not here having statute to analyze or judgments to look at and decide where we are going. The sky is the limit, it's open-ended. The ideas are available. The international communities are examining this issue. Issue of sovereignty is also there. And to what extent the foreign investment needs to be brought into that, in that context, how are we going to titrate the sovereignty issue is the real point which we need to discuss today. I have made a very short introduction, very short introduction, which will give you the context in which the discussion would take place. The law governing treaties is basically in the realm of public international law. And investor-state dispute settlement mechanism was an innovation designed to depoliticize and streamline investment disputes by allowing investors to directly make claims against the state under bilateral and multilateral treaties. This is intended only to protect the wealth as well as the property of foreign investors. How states fail to anticipate the varied problems that would manifest from the ISDS mechanism is what needs to be seen. One of the main criticisms of this system is that states have no role with respect to, had no role till today with respect to the ISDS. The criticism of this system related to the, unlike international courts, the interpretation that was adopted by the arbitral tribunals and having a direct bearing on the sovereignty issue. Whether they have transgressed or were well within their bounds is a matter which we are going to discuss shortly. In this background, we also look at the negotiations and then the material that's available of the UNCITRAL regime, and the one in context is the working groups deliberations, the third deliberation which is actually taking place now. Very many issues are flagged, and we're going to discuss even about that. So far as the Indian background is concerned, I think most of you are aware of the 83 bilateral investment treaties that we had entered into. Those were by the end of 2015. I would not take you very much into detail about how it all commenced with Dabhol and thereafter the White Industries case and leading to the cancellation of large number of PITs. But nevertheless, the sunset clause is there, on the basis of which these claims continue to arise, and we will have to deal with those claims. The real issue, yet again, is the 2016 treaty, and on that model BIT, and on that Justice Devan Ramachandran is going to tell us in detail. After that, we will examine what are the possibilities of, in fact, the very question of having a BIT itself will also be considered by us. If it is considered, then what are the minimum standards that we need to adopt? How are we going to balance the competing interests of bringing in foreign investment which is necessary for development, and at the same time not relinquish or dilute our sovereignty? These are the aspects which we are going to discuss, and some more ideas which I have, which I am going to share with you after the eminent speakers make their presentation. I will now, the method which we have decided to adopt is that we will have Justice Ramachandran to commence and give his presentation for about 15 minutes, 15 to 20 minutes. Thereafter, we will have Mr. Gourab Banerji to tell us about the other aspects of it and the new innovations that he would propose. And of course, after that, Professor Jones will follow. Subject to the time, then we will also be taking some questions from the audience, apart from my questions to these. You can sit here and yeah.
Good afternoon, ladies and gentlemen. What is under focus today is a concept which is now being found to be, or at least being accused to be, illegitimate on one side, unreasonable on the other, incoherent on the third, and unpredictable on the fourth. Perhaps the only reason, I'll take you through the history of BITS a little bit, but perhaps the only reason why the world thought of something like an investment treaty of the kind that we are now speaking about is because we thought that we must get foreign investment into our country quickly, lure the investors into us, and then give them some protections or some offers which cannot be normally refused. But unfortunately, the world went overboard. The first BIT was entered into in 1954. It was not called a BIT, but it has now got it partakes the character of a BIT. That is the between Germany and Pakistan in 1954. Now, I'll just come to the problems that the world faced after that. But then, before that, the Investor-State Dispute Settlement Regime, which normally now called the ISDS. Historically, if you look at it, we are all law students and we know this. Historically, the public international law never treated an individual as a subject, and normally they were not given any legal personality, generally deprived of legal personality, except in the case of wars or revolution where the tribunals were set up For example, the Jay's Tribunal, 1794, and the recent US-Iran claims tribunals. But that underwent a complete change when for commercial transactions, literally, states began to underwrite the investors' concerns. Now, technically, if you look at BIT in its specific form, what the state really does is to underwrite all their risks and give them an offer. Tell them that, look, if you bring in investment to my country, I will protect you and I'll ensure that you will not face anything which is discriminatory or in a manner that will expropriate your subject, either directly, indirectly, or which is now known as a creepingly, in a slow manner, slow poisoning, as they say. Now, originally, as I was saying, a private individual would have had to tap the diplomatic channels of his state and then reach out to the investing state and then get his grievances redressed. Or, at the best, he would have had been treated as an alien under the customary public international law, under the minimum standard protection concepts. Now, that underwent a complete change. Now, if you look at the bilateral investment treaties, or for that matter, even multilateral investment treaties of these days, it really encompasses future disputes. This is something that we must be really thinking about. And I'll explain it a little bit as I go along. It encompasses future disputes relating to indeterminate prospective investors to cover a wide gamut of governmental regulatory regimes. I'll explain. Now, when a BIT is entered into today, we are not foreseeing any problem. We do not think that there would be a grievance or a problem that is to be resolved immediately. So we are guaranteeing a grievance of a future event. It is not even a historical event. Now, who are protected? An indeterminate number of foreign and prospective investors. We do not even know who the investors would be. Because once the BITs are entered into, the investors come in, they make their investments, and then the protection starts with that. And then, what are we really doing? A state, I'm saying when I talk about we, I meant the state. The state gives up some of its regulatory control and tells the prospective investor that if you invest in India, for example, because we are in India, I'm using the name India. If you invest in India, we will protect you and we will ensure certain standards for you. Now, this looked like a very innocuous and easy kind of a regime. But tragically, this was not to be, as the world has shown us. Now, if you look at India specifically, I said the first BIT was entered into in the year 1954. If I'm taking too much of time, please stay.
No, go ahead.
It began in the year 1954. Now, India did not have its first BIT until 1994. That was a period of skepticism. We thought we'll have to wait and watch, as we always do. We always watch and see what really is happening to the world and then plunge head on. That's exactly what we did. We plunged head on. We started signing BITs left, right, center, north, south, east, west. And then we were happy with it. We had no trouble at all. Suddenly, the White Industries case happened. So there was a time of participation when we were entering into BITs, when we were making sure that the investments were flowing into our country, and we have done well, no doubt about it. But then after White Industries, we understood the pitfalls. It was not as easy. It was not a rosy journey all along. And then what did we do? We started issuing joint interpretative statements, as they call the JIS, to all the countries with which we have entered into BITs, telling them either that we are preparing and proposing to withdraw all the BITs, to cancel them, terminate them. But as Justice Narasimha rightly said, the sunset clauses are still there. We are still to be worried for the next 10 or 15 years, as the case may be. And then the JIS, the joint interpretative statements, are still in force. We have withdrawn many of our BITs, though we have entered into new ones with Belarus, with Taiwan, with Brazil, if I'm not mistaken. And most recently, we have entered into a CEPA, a CEPA, Comprehensive Economic Protection Agreement with the UAE. So India is now going on a very, very cautious approach. We are taking a very cautionary road ahead. And that is justified because we did not really understand the repercussions that the BITs can have And I'm saying this with Professor Doug Jones sitting next to me. He's an international arbitrator. I'm exactly aware what is going through his mind now. Now, when you look at the general application of the BITs, as I said, generally for a public or a private individual, you cannot sue a state because the state would always impel its sovereign immunity from that. But by entering into a BIT, what the state really does is that it cedes, it gives up its sovereign immunity in the event of a litigation or a cause against it, and that too without any privity to the underlying commercial contract. Please understand the intricacy of that arrangement. This is why it is called illegitimate sometimes, because public international law never postulates a claim against a state with which it had no privity at all. So, for example, two of us enter into a contract, one in US, one in India, under a BIT. The state has got nothing to do with it. But then, when there is a regulatory measure brought in by the state, the investor then says that, look, this is contrary to the BIT. You have broken your promise, which was intended to be the underlying leitmotif for the contract, and therefore, I'm going to sue you. So the state gives up, in such conditions, it gives up its sovereign immunity to litigation, and then exposes itself into causes of action which we could have never ever foreseen at the time when the contracts were entered into. So this in essential is what India faced in the last few years. And as I was saying, I'm going to rush through now. I think if the pace which I'm going now, I don't think it'll be easy for me to close what I wanted to say. Now, generally with respect to a BIT, I have noted it down because there are several concerns which are now internationally accepted. As I was saying, a BIT is criticized for being not transparent, because generally the contracts are not with the state. I said the state has no privity to the underlying commercial contract. Then what happens? Two people, two investors, and somebody else makes a litigation or causes a claim, which is not made public at all. It is all done within closed doors. Nothing is brought out, at least until now. Now I'll come to that also. There have been some measures of transparency tried to be brought in. The second most important criticism is that there is no uniformity, because the tribunals are either under the mechanisms of arbitration agencies, or under the UNCITRAL system, which makes an ad hoc arbitration tribunal very legitimate. In fact, Professor Jones will be speaking about that also. We had a discussion when we were speaking behind the scenes. The third most important is that uncertainty. This is because in the international arbitration relating to BITs, there is no stare decisis, no precedence. Nothing. There are no conditions imposed at all. So there are arbitrators who pass orders without being aware of the trends in the other parts of the world, and you get very uncertain kind of awards that are coming in, which cannot be generally challenged in the manner that a state would like to, because of the diplomatic issues and the New York Convention. The third is that generally, as I was just saying, the underlying problem is that bias to investors. So basically, you are now ceding to the investor, a foreign investor, more than what you could have given to your domestic investor. This is one of the biggest criticisms of the BIS system. And then the interpretation of the clauses. Now, this is very interesting. For example, we make a treaty being aware of our laws, our ethos, and our traditions. Every country has its own methods. So we generally enter into a treaty being completely guided by what we are used to. But then the interpretation that is given to it is by the ad hoc tribunals sitting somewhere else, like Professor Jones here. And then the interpretations are completely varied from what we ever intended it to be. And this is also given rise, I'm not taking the specifics, because I think as a serving judge, it is better that we don't keep our opinions in the public. Now, therefore, the legitimacy of the system has been called into question very badly. And then, I'm just speaking about it peripherally. I don't want to deal with it in detail. In fact, I heard Dr. Muralidhar in the other session. You were talking about fraud. Now, that is one of the biggest concerns that we are now seeing, because we do not know the underlying objective of the contract many times. Because as I said, the state underwrites that contract virtually. And it does not have any information whether the underlying objects, what are the credibility or the efficacy of the underlying contract. So that is one thing that a state will have to be very careful of. And I'll come to the model BITS of 2016. It takes care of all this. which I'm sure people like the international arbitrators would be criticizing India for having a very cautious approach. Now, domestic laws are generally disregarded. This is another criticism for BITS, and rightfully so, because once it enters into the public international arena, domestic laws really have absolutely no role to play. Now, what is a way forward? Because that is a topic that we are talking about. I would have come to this slightly later, but then owing by the constraints of time, I'll deal with it straight away. I was talking to our panelists before we started the session. Most of the arbitrators are not tenured judges. So this is one criticism that I thought should be kept in mind by all the international agencies also. We are all bound by treaties between states or multilateral agencies, but then none of the arbitrators are tenured judges. How they are chosen, we have no idea. That is why in the new CETA, that is the Canadian-European Treaty, right? They provide for the qualifications of judges to be now appointed. I'm sorry, for the arbitrators to be now appointed. This is something which the world will certainly have to be. And then the second would be to interpret the clauses very strongly, very, very narrowly and very strictly, for which possibly you can have, interpretational tools like exceptions and reservations drawn in. One small suggestion which I thought, I'm not sure if this has ever been spoken about, is the discussion that happens before a BITS is entered into, what we know as the travaux preparatoires. If that can be made public, perhaps like the parliamentary debates prior to the making of a law, because treaties are not really laws at all, really speaking, because the Indian Parliament does not pass the treaty. It is all done by the government on either on a bilateral basis or on a multilateral basis. But as one of the other sessions said, I was listening to almost all the other sessions. Finally, I think Mausumi said this, finally, the burden is taken by the people of the country. Now, the costs, that's another major problem which we find with the BITS, and compensation. Absolutely disproportionate costs, absolutely disproportionate compensation, which can really make a country go ruin. And if the multiple awards are passed, and we are now obligated to honor all of them because of the New York Convention, frankly, and I'm happy that we have not ratified the ICSID convention yet, which is the International Center for Settlement of Investor Disputes. But then we are bound by the New York Convention. We are bound to honor the treaties to the extent that we are expected to. And therefore, when we are dealing with the new BITS, we find two major problems now, even now. One is the question of forum shopping. You find a situation where companies are incorporated solely for the purpose of the BITS. They find out the forum which is the most apposite to them, create shell companies here and there, bring out seats of arbitrations, and then destroy the home state. Only why? Because it is endeavored to make a BITS. The second, and which is now really the most important, would be third-party funding. Professor Jones perhaps is more conversant with this. There is no disclosure of third-party funding in any of the BITS claims. Gourab, perhaps you can also deal with that as a practicing counsel. Now, but recently, I believe it is a CETA again. I may be wrong, or is it the Pan Asian Investment Code? I do not know. There is a mandatory disclosure now required of third-party funding, direct or indirect. So these were the issues that plagued the BITS regime until now. Now, very interestingly, everybody was talking about the Netherlands BIT as a gold standard. It was an open BITS with hardly any restrictions, to say the same. But then the BIT Netherlands has been completely revamped. It is now so strict because the threshold of who an investor is, what is an investor, has all been made very, very tight. Therefore, I'll now take you back into the model BITs that India has now proposed. Quickly, I will not take too much of time. Now, the model BIT is definitely under criticism. I'm sure some of our panelists will also share that concern. Because from a commercial point of view, what we have done is to actually walk back from the posture that we have seen in the past. Now, the model BITS now protects measures by the local government, local self-government institutions. Imagine earlier, apart from the union government, any decision taken by the local self-government institutions would also be a reason why a claim under the BITS would be triggered. That has now been taken care of. Now, taxation. I'm not saying which case. I think judges and the lawyers here know which case I'm referring to. Taxation is now taken out of the ambit of the BIT, especially when it is done by the Reserve Bank under a monetary policy or an institutional system. Compulsory IP licensing, this again has been taken out of the BIT. Government procurement, wherever we are making concerns for government, provisions for government procurement, that is taken out of the BIT's net now. Subsidies to vulnerable people, protection of human, plant, animal life, all these are now taken out of the from the model BITS now. Essential government services, essential security requirements, national and emergency clauses, and then there is something called the denial of benefits, where the state has reason to believe that measures have already been taken against an investor in the past. And if you keep that covered and enter into a BIT and then seek its protection, that is now denied. I am certainly of the view that this is a complete backlash to what we saw in the past, and particularly because, interestingly, the model BITS now, 2016, does not even have an umbrella clause. Even the umbrella clause has been taken away. So it's possibly now, the recrimination would be it is state-centric, but perhaps this is the way the world is now going. So moving along, what is the future for BITS? It's going to be state-centric to a large extent. There would be a lot of restrictions that will be placed on the manner in which the protection under the BITS could be taken. For example, exhaustion of local remedies. That was completely missing from our earlier BITS. Now we have a 5-year term. You have to exhaust your local remedies before an individualized claim can be brought in under what is known as the Frankowitz doctrine, where an individual can claim compensation from a state. So these are the changes that now we are now slowly seeing. And I believe that this is the way the modern regime of ISDS would be taken forward. Unlike the completely relaxed EC terms and investor-centric, investor-friendly, protectionist kind of regime. I'll reserve the rest for the other panelists to complete.
Thank you. Thank you, Justice Ramachandran. You have divided it, if I may just indicate, so that Gourab can take it forward from there.
Yeah.
You have broadly bifurcated it into legitimacy issue as a primary issue, and then procedural aspects of it. Legitimacy issue is a very important issue that is linked to the question as to, on the one hand, we need an investment, so we need to make India more attractive, and at the same time not lose the sovereignty part of it, the legislative power too. How do we balance?
Absolutely.
And to what extent? If we balance it as indicated in the 2016 BIT, will there be takers? If there are no takers, then what do we do? Is the real dilemma and the question which we need to consider. And on the procedural parts of it, many of the issues like transparency, no uniformity, uncertainty, bias, interpretations are to some extent there in the domestic tribunals also. But then they are far more aggravated so far as the international arbitration is concerned, and something which is a matter of very serious concern is the cost part of it.
Yes.
Definitely cost part of it. And model BIT, of course, we would request Gourab Banerji to make his presentation and deal with all these issues. Gourab?
Thank you so much.
It's on.
Good afternoon, everybody. A number of issues have been raised by Justice Ramachandran, and I am actually going to deviate from some of what has been said. I have already put in a paper with a colleague of mine, which you'll find in your bundle somewhere. So I'm going to tell you a little bit more about specific instances and practical implications before going on to the model BIT and the sunset clause. The first question, which I think one can legitimately ask, is what is this investment treaty business doing in an arbitration conference? All of us are familiar with commercial arbitration to some or greater extent. Some of us are familiar with international commercial arbitration. But this is a completely different creature. And I think we have to get used to the fact that this is a completely different creature. It is not commercial arbitration. It has a very significant effect, element of public interest law, treaty interpretation. It involves many more aspects than disputes between two private individuals, which is the classic case where you have consent. It involves a country giving up some of its sovereignty in order to get some investment, and it permits an individual of a different country to straightaway arbitrate before a neutral forum and enforce various rights. Now that's quite a leap, and I think when India started signing these agreements, we really didn't have any idea as to what we were letting ourselves in for. And I think that's the reality. And I think as citizens, apart from being judges, lawyers, etc., as citizens we should be very worried on two counts. One is there are massive awards which have come against our country, which certainly impact tax-paying citizens. And secondly, there are issues which are not private law issues. There are issues which are regulatory issues. Our Supreme Court's conduct has been questioned in arbitral awards. So I think we really need to recalibrate, think about this a little more deeply and educate ourselves. I think that's really the message here. So what I'm going to do is, before I respond to what Justice Ramachandran says, is take you through the Indian experience, concrete examples. Fortunately, I am not barred by any office from saying whatever I feel, and I'm not responsible to anybody. So please forgive me if I say some things which are somewhat unpalatable. So I'm going to take you through two or three or four cases, practical impact on India, what is the solution, and how have we proceeded, where we have got it right, and where I think we still need to look at, because it has very serious implications for all of us. Now you would have heard Justice Ramachandran, and the fact of the matter is that 76 odd BITs, the plug was pulled by the Indian government. Why? I think it was a reaction to white industries, it was a reaction to various other disputes like Vodafone. I'm not on the merits, Vodafone, Ken, Vedanta, Antrix, Devas. So the government of India decided enough, I pull the plug. Slight problem here. The two words sunset clause are devastating. So a sunset clause, essentially, all these 76 BITs that we have terminated all have sunset clauses of 10 to 15 years. So all investments made until 2016 can be enforced through arbitration. So we cannot run away from the fact that we are stuck with 70, 80, 90 BITs, and we are stuck with BITs which were, shall we say, negotiated in the 90s, where there was really no negotiation. And the problem with these BITs is a fundamental problem which we are now realizing. In our eagerness to get investment post-liberalization, the clauses that we agreed to were very, very wide. So you would now, some of you would have come across these acronyms, FET, MFN, all these random acronyms. But the fact of the matter is, you have a treaty, it's not like a commercial document, you have a treaty with a wide, possibly wide interpretation. What is fair and equitable treatment? I mean, it can mean anything. One tribunal may say X, one tribunal may say Y. So we are now stuck with this issue and we need to deal with it. But I will deal with it later. Let me give you some concrete examples of how we have dealt with it, what we have got right and what we have got wrong. Everybody starts with white industries. So I was part of white industries for a while, so I will tell you something about it, but it's quite interesting. But what I would like to start with is something completely different. Dabhol. People have forgotten about Dabhol. Dabhol was the first major attack through the Indo-Mauritius BIT. Many of you, obviously, the older generation know about the Dabhol dispute, but I am relatively sure some people sitting at the back have no idea what the issue was. So therefore, I'll take 2 minutes just to explain what happened. So 91 liberalization, 93 power purchase agreement between Dabhol and the Maharashtra State Electricity Board. It was a $3.6 billion investment. All the big boys were there. Enron was there. Bechtel was there. GE was there. Contract entered into. It was mired in controversy from the beginning. The price was too high. The World Bank said the price was too high. We signed on the dotted line. There were whiff of corruption, etc., etc., etc. We'll not go into the merits. Now, when that matter, as it inevitably had to be, when the PPA was terminated, the counterparty went for arbitration. Inevitable. It was a commercial arbitration. Then the regulator stepped in and said, look, this is not really an arbitrable dispute. It is, the regulator has the power, whatever it was, whatever the reasons were. Then the ante was upped and Bechtel and GE filed these investment treaty arbitrations through the Mauritius route. They had set up, they had thought this through, they had set up Mauritius subsidiaries, they filed it through. So the government of India, and I know for a fact, did not know what this was. They had no idea what is this BIT, what is this investment treaty, how can some individual come and file a case against the Republic of India. And remember, Republic of India had given counter guarantees. Government of India, Maharashtra had given guarantees. I mean, it was a delight for us lawyers. There were hundreds of cases going on. But anyway, the only reason I mentioned this case, two reasons I mentioned. One, it was settled. A lot of people criticized it at the time, but I know the numbers involved. It was a great settlement. We escaped by the skin of our teeth. We had no significant paperwork to back up the decision to expropriate. It was settled at X 100 million. It was settled at the highest level. It was a diplomatic effort. The other side had Colin Powell, Dick Cheney. The Prime Minister spoke to Bush, Clinton. So it was settled at that sort of level, but it was settled. Some amount was paid, matter was closed. So good thing settled, bad thing, everybody forgot about BIT after that. Settled, all right, this problem is solved, forget about the 80 BITs. The second aspect which is very, very striking in that matter is, I remember at one point of time, the Indian government wanted to engage UK and US lawyers, because we did not at that time have the capacity. It was a esoteric subject. It was not like the usual commercial dispute. We didn't know. So the government wanted to approach these people. And out of 35 US and UK law firms that were interviewed, 30 was conflicted out. GE and Bechtel had blocked 30. So you're left with 5, you're left with a poor choice. So one lesson I think that we need to learn, and we are still in the process of learning, is build capacity, and while you're building capacity, get access to the club of lawyers and arbitrators who have this, shall we say, expertise even now, because it's relatively small club. So that's what I want to say about Dabhol. Don't forget Dabhol. It is relevant. Even today there's a problem with the pricing, but I mean it is that gas which is being brought in from Qatar, LNG gas which is being brought in. But anyway, that's a separate saga. So Dabhol was the first strike where we dodged a bullet, Government of India dodged a bullet and promptly forgot about everything. So now you come to the famous or infamous White Industries. Now the first thing to remember about White Industries was, it was a tiny case. The award in White Industries was $4 million. We are now facing awards of 562, some Mickey Mouse numbers which we don't understand. But it was a small case with an award of $4 million. Why did we lose? So the award is actually now available on the net for anybody who wants to read it. We lost on a very small technical point, but which created a furor, and I'm coming to that. So 10 or 11 points were argued. India succeeded on every point except the last. So no expropriation, no FET, no this, no that, no. but we lost. And it was not because the government of India had engaged useless lawyers. The government had engaged Toby Landau, QC, then QC, and Salim Mullan, who I think one can accept did know the law reasonably well. And the tribunal, I think Bill Rowley was here in some other session, was Bill Rowley, Charlie Brar, and Christopher Lau, went off on a complete tangent. I mean, I still think it was a ridiculous award. I can say that now. There was a challenge which was drafted, but for some reason not filed. I can see somebody smiling, so I will not say why it was not filed. But the reasoning was that because the Supreme Court of India had not decided the case for 8 years, therefore the government of India or the Republic of India had not granted White effective means to enforce its award. Great point. Only thing was that that provision was not there in the treaty. So what did the tribunal do? They went, used the MFN clause and borrowed it from the Indo-Kuwait treaty, which practically was, I mean, I would have spoken to maybe 30, 40, I mean, there are only 30, 40, 50 people, people who do this, and it was an extraordinary decision. But it was a very small award. It was a 4 million award. But what is the lesson there? So I'll tell you what the lesson as to why White should never have happened. The lesson is, you have now blamed the Supreme Court for keeping the matter pending for 8 years. Okay, fine. That itself is wrong, but anyway. The advice of Toby Landau was, Gourab, go back, go to your Supreme Court, mention the matter, get it listed, argue it one way or the other, doesn't matter what the result is, close this sham. So predictably that was done. For one reason or the other, that matter was heard 1 year after the award. And that matter, you will be interested to know and you will all laugh, was Balco. So Balco Kaiser's second matter was White Industries. And the dispute in White Industries was, Coal India had suffered an ICC award, the seat was outside, the law was Indian law, whether it was part 1, part 2, matter was pending in the constitution bench. Had the Supreme Court been aware or understood the gravity of the problem, they were not told that, look, by merely not deciding something, you are exposing the country to some award by some third party. Maybe had they decided it, you would not have had a White. So I think the lesson here is that we need to educate, very difficult to say this, our judiciary, our regulators, our government servants. Government servants are terribly bad. The judiciary will grasp it relatively quickly. Government servants are terribly bad. You want, if you want them to appear in a tribunal and be cross-examined by some this thing, they can't handle it. They say, I am the government of India. I have decided this is a matter of policy. It is my regulatory act. It is my policy decision. How dare you question me? So it's an issue. So lesson 1, so far as DAW is concerned, is build capacity. Lesson 2, so far as White is concerned, forget the merits. I'm still cut up about the merits. Forget the merits. It's a wrong order according to me, and that's a separate matter. But 2, educate every part of the government to understand what the risk is, the risk factor. The paperwork has to be complete. The if you have the paper trail, you will win your BIT. So that's the second lesson. In fact, I can see somebody in the audience. We have the PCA and the MEA had a 3-day detailed training session. I was also part of it. We got people from abroad. We got Vandenberg, we got Andrea Menica, we got Professor Veeravantri, and we had about 80 people from the MEA, and we had a 3-day, Mr. Nariman of course was in charge, Ali Nariman was in charge, and we had a 3-day training, and the sort of questions that senior officers of the MEA were asking us was so depressing and shocking that some of them genuinely wanted to know how they were being questioned by some 3 foreigners sitting in The Hague. So that's the second case. The third case, if I'm not running short, the third case, which is very interesting, is Antrix Devas. So there are various people here who have been involved in Antrix Devas at some stage in some fashion. I am deliberately not saying anything about Vodafone, Ken, Vedanta. I can see somebody there who knows a lot more about it than I do, but I'm not going to say anything about Ken. But I'm glad it got settled. That was a bit of a misadventure, but we leave it there. So Antrix Devas, so what is my complaint about Antrix Devas? So what was Antrix Devas? It was an agreement between Antrix, which we now pronounce as Antrix, but it actually is Antrix, as in space. But everybody, even the gentleman, the CMD of Antrix says Antrix, so we're saying Antrix. And Devas is, I wrote it down somewhere. I discovered what Devas is. It's quite interesting. Devas is data, digitally enhanced video and audio services. So the contract was, very interesting contract, nobody knows this, is that you have your mobile phones and you have terrestrial mobile towers. What these gentlemen wanted to do was to have the same thing but through satellite. So ISRO through Antrix gave that S-band width ISRO was to put up 2 satellites. Some of the transponder width was to be given to this company called Devas. Slight problem, Devas consisted of, some retired former employees of ISRO. It were about 10, 12 people. We're not even going to go into the corruption aspect, etc. Anyway, so this went through, everything was fine, then 2G happened. That itself is another problem. There are some cases, I don't know whether they're pending, they're still over. 2G, so 2G judgment came, large number of 2G licenses were cancelled. That has given rise to about 4 or 5 expropriation cases. Again, perhaps the judiciary didn't realize the impact of that 2G judgment internationally in terms of litigation against the country, because the Supreme Court is part of the state, is part of the Republic of India. Anyway, so in Antrix, all this happened, great. Suddenly 2G judgment came, government took a relook, government said, okay, I am not going to get into this mess at the highest level, we will reserve this for national security. So, spectrum reserved for national security, commercial contract terminated, force majeure. I would have said force majeure is a great defense. Government of India has cancelled your contract, ICC commercial contract cancelled. Amazingly, we lost the ICC arbitration. The reasoning in the ICC arbitration, apart from other things, I came in later, is that the chairman ISRO should have convinced the government not to cancel the contract, and therefore it's not force majeure. I mean, it's an award worth reading. Anyway, my complaint about Antrix Devas is a slightly different one. Now it's still being litigated, corruption, etc. It's still being litigated. That's fine. Supreme Court has pronounced. For an 11 or 10 member company, an ICC tribunal is awarding $654 million as damages. 4,500 crores. You didn't set up one phone. Your system did not work. You didn't have the technology. That's fine. The DCF system, projection, experts, and reflected. Now, this is like a hen laying eggs. So you've got the ICC award, 654. Then you've got the DT award, which is an award under the Indo-German BIT for 100-200 million. Then you've got another award, Mauritius award for 100-200 million. I mean, this is like monopoly money. So this is my main objection to Antrix Devas is, whatever be the merits, assuming the government could not or the Antrix could not satisfy you, which I have great doubt. This is one problem that the international community of ISDS has to address. Absolutely ridiculously huge awards. And this is not a private dispute. This award of DT or this thing comes from your pocket because it's the government of India. So these are the 3 cases that I wanted to illustrate just by way of example to show that these are lessons to be learnt. We are in the process of learning those lessons, and there are a number of aspects. I don't actually think that the model BIT is the solution. The model BIT basically says, I don't want to sign any more BITs. You can get one model BIT with Bangladesh or Brazil or something. No major country will sign this revised BIT, because you have gone from extreme laissez-faire to extreme state protection. So there's no meaning of signing that document. You talk to any of the embassies or any of the foreign parties, they're not going to sign it. I think we need to. There are other problems with other concerns. So I'll just quickly complete this. One is very widely drafted. Two is basically BITs legislate on public matters, public policy. So whether it is 2G, whether is it courts functioning, whether it is taxation, it legislates on public matters. So there is a public law element which requires some greater degree of transparency. So one areas of transparency, there's of course the Transparency Convention now. The major problem with BIT I find is, and the elephant in the room, and I'll conclude with the elephant in the room. The elephant in the room is this, that unlike international commercial arbitration, where the pool is relatively wide, today very few arbitral choices are available in BIT arbitrations. And there also people are committed. You are a state appointed arbitrator or you are an investment appointed arbitrator. You know, it completely defeats the whole purpose of arbitration. You have a chair, as Professor Jones has been a chair in all his ISDS, and it's as he put it to me over lunch, it's a very lonely affair. One person is going to vote one way, regardless of the merits. One person is going to vote the other way. So you have to decide. So there is a massive credibility crisis with the ISDS system. Everybody acknowledges it. There are a group of people who are trying to rescue it. So there's the UNCITRAL working group. There are people here who are advising our government on what to say in the UNCITRAL working group. But that is, I think, too little, because that is only procedural. Something about double hatting, something about, have a more smooth system, have an appeal procedure, maybe have a court. These are all band-aid solutions. The other extreme is, let's wash our hands of this regime in totality. Some people advocate that, but the fact of the matter is we are stuck with it for 10 to 15 years. So we should get our act together and we should educate ourselves, get our paperwork in order. We may perceive it as a tilted field, but we have to fight the battle. You can't get away from it.
Thank you very much, Gourab. Yes, the sunset clauses haunt us and we have to deal with it. The case in Dabhol as well as the small issue in white industries has subsequently rolled over and has created much of problem. One interesting thing comes to my mind when you have said that judges also need to be educated. When I went to Hamburg to argue the Italian Marines case, the mandate that I had was to prevent the tribunal from giving a direction to India to send away the Marines back to Italy. So we raised this point that they had invoked India's jurisdiction and India went backwards to accommodate them, to the extent that no ordinary citizen would get that kind of a relief. India had given him all those reliefs. And you can't now come here and then say that India has failed and all that. And I said that we are going to treat them here and we are going to create a tribunal also for early disposal. The 21-member bench agreed and said, okay, as Additional Solicitor General, we agree that you have treated them well. We will not pass an interim order. To that extent, we were successful. When we came back, I was to abide by the undertaking that I have given to the ITLOS. So went to the Supreme Court and said they need to leave our country and go to Italy because Christmas is coming. And so one of our judges, there was a 3-judge bench, one of our judges said that, who are they to tell us? So I had to tell him that it is not they, it's our undertaking, and I represent Republic of India, which will include the Supreme Court. So it's our undertaking which needs to be abided, and the court deliberated and permitted that to be done. So therefore, it's a matter of information. And another very important aspect of it, before I request Professor, is this Antariksh aspect of it. Again, that requires a capacity building. A lot of deficiency, a lot of problems that arose. I was witness to that in my appearance. A lot of problems arose because of the lack of capacity. We will come back to that point after we hear Professor in his presentation, and he will be dealing with MIC and other issues also. Thank you.
Well, thank you very much, Your Honour. It is a great privilege and a great pleasure to be invited to speak at this amazing conference. It's my first trip back to India since COVID, but the frisson of energy around arbitration has changed dramatically since I was last here in 2019, and this conference is an eloquent statement of that. So I'm very pleased to be participating. I've done quite a big paper, which I won't go through now, although I'll read it all if you want me to. So I'll just speak to a couple of issues, if I can. Fundamentally, I think that the whole area of investment protection has to be carefully divided into creation of whatever additional rights providers of foreign direct investment to be given in addition to those of the citizens of the country, which is the drafting of the bilateral or multilateral investment treaty, and the process whereby investors can obtain redress if they think that whatever those rights are have been traduced. And keeping the two things separate is really important. I speak with some trepidation, having come from the home country of white industries. But I'm sure you all readily appreciate that you have your revenge regularly in the cricket, including at the moment. Just a couple of anecdotes. When I was just commencing university, there was a decision made by the federal government of Australia to preserve the largest sand island in the world, which was then called Fraser Island. On Fraser Island, there were some massive rutile sand mining leases being exploited by an American company called Dillingham, of whom you may have heard. All the leases were cancelled and it was declared a national park, which for Australians was very good news because it's quite a unique environment. Dillingham, though, were quite upset. They said, we've got these leases that are running for a significant period of time and we've just been kicked out. So they went back home, and the US State Department, in the context of enforcing rights of American investors in Australia, which was part of a treaty, commenced proceedings in the International Court of Justice on behalf of Dillingham, which then was the only mechanism by which investors' rights could be pursued. That is, their country had to take proceedings on their behalf, a little bit like WTO-type proceedings. That happened to coincide with the massive American involvement in Vietnam, in which I had a peripheral interest because the US asked Australia to send troops to Vietnam. And ever since the fall of Singapore, when we lost faith in the British, we've relied on our alliance with the Americans very much for our own defence. So broadly speaking, when they say jump, we say, how high would that be? But in this instance, there was some negotiation along these lines. You've taken proceedings against us in the ICJ over Fraser Island. If you expect us to send troops, you've got to stop those proceedings. US said, okay. You impose conscription, you send troops to Vietnam, we'll discontinue the proceedings. Dillingham, of course, were left lamenting with no compensation for the removal of their licenses. So that was the risk that was faced by investors relying upon the dispute resolution or enforcement of rights procedure then available for rights given to investors under investment agreements. Fast forward to about 5 or 6 years ago. The Australian government decided to enforce a plain packaging requirement for cigarettes. And as you would know, the cigarette lobby is pretty intense. And Philip Morris, one of the cigarette manufacturers and sales people in Australia, commenced proceedings under the Hong Kong-Australian Bilateral Investment Treaty, saying that their intellectual property had been appropriated or misappropriated expropriated by the Australian government. And the reaction of Australians, ordinary Australians, who knew absolutely nothing about what we're talking about, was visceral. How dare this tobacco company try to interfere in the exercise of public policy trying to save lives of Australians? And the reaction was so strong that the Australian government said, we're going to take all ISDS clauses out of any future bids. We will not agree to this dispute resolution process. That was before, after about 2 years, the Philip Morris case was thrown out by the tribunal that was appointed. But the debate was a political debate against the capacity, the temerity of big business to dictate how government would look after its people. Now that's the context in which we are presently debating the dispute resolution mechanisms provided in investment agreements. And I say that because I'd like to keep distinct what the rights might be, perhaps additional to the rights of citizens with foreign investors, and how those rights are exercised. As you've heard, the problem of Dillingham was eventually solved by the creation of the possibility that investors themselves could take proceedings to enforce what they regarded as breaches of the undertakings given by states under investment treaties. And what was chosen was a dispute resolution mechanism which tacked on the international commercial arbitration process, which had been so successful and was so widely used by parties who trade with parties from other countries and seek to have a neutral resolution of their disputes. And I think somehow in the debate, some of the gurus in international commercial arbitration persuaded governments that this process would work. The problem was that by adopting the international commercial process and converting it, say in the ICSID context, into a very similar sort of process, there was let loose the dogs of war who would otherwise be called the international law firms, who saw a huge opportunity to add a whole new area of practice to their endeavours. I said maybe 10 years ago, as I was watching the feeding frenzy of the international lawyers in this space, you are going to kill the goose that laid the golden egg if you are not careful. But of course they weren't careful. How can any lawyer pull back from a fancy argument like the Supreme Court's not enforcing my award in India? And a good friend of mine actually ran that case. I'd heard about it and I thought, now there's a flyer if I've ever seen one. But it succeeded. And what's happened is that the boundaries of arguments run as to what these investment treaties mean in these international arbitration bodies has exceeded the tolerance of states to accept the outcome. Because for a process like this, there needs to be an acceptance by states of the outcome. There needs to be an acceptance of the outcome of decisions of judges domestically. If no one trusts what the judges in India do, you have a pretty poor process of dispute resolution. So the whole process of commercial and international dispute resolution depends upon an agreement between those who participate to trust and accept the system. And so there's been a loss of that trust, and particularly in the EU. If you look at the feeding frenzy in Spain over their attempts to reform their electricity process and move towards a green environment, it's just extraordinary what Spain has faced in terms of claims by people who had invested in the electricity industry and say, you changed the regulation contrary to the provisions of whatever bilateral investment treaty or multilateral investment treaty there might be. And the EU has said, we're done with arbitration. We're done with arbitration because people like me should not be allowed to determine what we can do as a matter of public policy, and what's more, take away perhaps half or more of the GDP of developing countries who are accused of having breached their duties under bilateral investment treaties. And so we see the creation, as we've already heard, of some other dispute resolution body, maybe a permanent court or something of that sort, to actually hear these cases. We clearly need something which enables investors not to be subject to the whims of the US government for Dillingham. We need something where there will be some level of assurance that investors can exercise their rights, if there are any, in addition to whatever contractual rights they might have with the state or whatever under a license or whatever. I mean, whether they should have additional rights is a separate, I suggest, policy issue for the purpose of encouraging foreign direct investment. I've heard a lot of debate over the years about why you need ISDS to make FDI work, and I've never seen any statistics which convince me that investors really decide whether they're going to provide FDI on whether or not there's an ISDS process. It's just not been proven. I'm not saying it doesn't happen, but I've just not seen any statistics. But nevertheless, there needs to be some mechanism. And the debate which is running at the moment, and which I deal with in my paper and which my co-speakers have also dealt with, is how do we find a mechanism which avoids the Dillingham environment? Another anecdote, I guess, in relation to having investment protection, which can be enforced in some way, is the history lesson of Iran. The Shah would never have been put into power in Iran if the government that had expropriated the oil revenue licenses had not been overthrown by a combination of the CIA and MI5. And so the whole history of Iran would be completely different if there had been a way of dealing with that oil issue. So we need something. What it is going to be, I'm not sure. Sunset clauses ensure that there's going to be a fair bit of stuff still going on, even with the countries that are seeking now to terminate their bits. And the ICSID caseload and the caseload of ad hoc investor-state disputes continues to rise. So you'd say, at least in the runoff period for the next maybe 10 years, this is going to be around. And there's still going to be work for the dogs of war. But we need to stand back and say, as members of the international legal community, what is best for maintaining respect for a dispute resolution process moving ahead. So that's the second last thing I want to say. The last thing I want to say is this. You're all very worried in India about these ISDS cases that are being run. However, I might be completely misconceiving the future. But for me, India is likely to be one of the top 3 economies in the world in a relatively short period of time. If you look at the approach of China to ISDS, you can see over the last 10 years a very sharp U-turn in their interest in ISDS from, goodness me, we don't want to have people taking proceedings against us when they're investing in China, to we want to protect our investments in Africa and South America and wherever else we're going, because they've become a net exporter of FDI. And so it must be the case with India. So I would encourage you not to think too retrospectively, but to think prospectively. Because amongst the dogs of war that might be here, there could be a huge amount of work for Indian investors who are going offshore. So that's maybe a positive thing to say about all the worries about what's happening right now. Thank you.
Thank you very much, Professor. Though it was heartening to think that India could be a real big exporter in times to come, but I just wanted to know from you also, there is still a need for reforming the existing dispute resolution system. And what would you suggest that the future could be with respect to reforming the existing system? Keeping in view the suggestions or the deliberations that are going on with respect to the working group, which also suggests perhaps something like a court or a tribunal, appellate tribunal thereafter.
I think, to be perfectly frank, that retrieving the existing arbitration system is a big ask. And therefore, I am looking with great interest at the prospects of established standing tribunals that will deal with the issues that investors face wherever they may have rights in addition to the rights of the citizens of the state in which they're investing. The EU's establishment of the court process that they are doing, certainly in the Canadian context, is very interesting. There's a huge amount of criticism of that, of course, from the vested interests created by a whole business area of ISDS. So one has to realise that that won't be given up easily. But for states to appreciate what serves their interests best is really important. I mean, the US has a huge influence in this, but they haven't been successfully sued very often at all. They sort of knock the Canadians off regularly and never really pay for it. And I'm not sure that the Mexicans have done terribly well either out of NAFTA. So I'm not sure that the US is particularly motivated to find a solution to this. China's staying relatively silent on the debate, and the EU, of course, is going hammer and tongs to try and change things. I would have thought India had a role to play in this, in the context not of we hate what's happening to us now, but rather where will we be going in the future? So it's got to be a policy change driven by government policy. I think we lawyers have to recognise that we are part of a system that is so seriously under threat that we're not listened to terribly much.
Okay. Thank you very much. We are almost at the end of the session. It's almost 4 o'clock. Perhaps we can take 1 or 2 questions.
Yes, sir. Yeah,
You can.
a couple of questions. Yes. The floor is open for questions, please. Can you pass the mics?
Hello, my name is Bhushan Satish. Hi. How might you react to the suggestion that the shock and awe that meets large arbitral awards isn't nearly equaled by the shock and awe that should be precipitated by egregious state conduct? And the fact that we, so easily talk about bureaucrats who are surprised that their conduct can be questioned, I think is the point. And if we have any respect for the idea of international rule of law, then we shouldn't be asking ourselves, all right, is there a causation, is there a causal relation or a correlation between signing a document and getting FDI flows? No one asks, no one even tries, one shouldn't attempt to try and sort of quantify in monetary terms the importance of the international rule of law. And that should, I would suggest, and I would love your response to this, perhaps that's one reason why the question should not be whether foreign investors get preferential treatment in terms of access to justice. Rather, why don't domestic investors?
That's right.
And a quick comment, perhaps, in terms of the costing of this entire enterprise, is there any, perhaps you would have insight into this, is the government of India maybe thinking of having maybe sort of a standing in-house team to deal with investment disputes the way Spain does or the way Argentina has done, to varying degrees of success, to sort of, given that we are now repeat players, unfortunately, in the game?
Gourab?
So I think, there's an assumption there that it is the egregious conduct of state officials that results in these awards. We've been doing an analysis of the various awards that have gone against the government, and there are some awards that have gone in favor of the government. And I think the problem here is much more a lack of documentation and communication rather than egregious conduct like walking in and taking over some property and throwing people out. I mean, many of these questioned acts had some policy basis. Even if you, I personally think the Vodafone judgment was wrong. I also think what was done thereafter was equally wrong. But there was some policy basis for it. So I wouldn't say that that it's a pushback, but I think you're right. So there has to be some degree of education and better defense of government conduct.
Correct, you're right. In fact, Justice Sri Krishna Commission's report provides the entire recommendations consists of how the institution has to be built up, and a full-time member of the status of an additional Solicitor General has to be appointed. And all those recommendations are there. I think only 5% of it has been put in place. Not even 5%, I suppose.
No, they have not.
Perhaps it's for the government to take a call on that.
I just
Anybody
want to just one line. Now, the question is egregious state conduct. The tragedy is, what is egregious is left to the tribunal to decide. This is the biggest tragedy under the ICDS regime. There is no definition. Now, the problem is that the tribunal believes this is egregious bad conduct. It is so. This is the problem. But I would rather think that the way forward for the BITS regime, as I said, as a serving officer, it will be very difficult for us to put our opinion through. But then would be to equalize the prospects of the foreign investor on par with the domestic investor. Not give any preferences. Make them equal, give them a protection as you would give it to the domestic investor also. But we have to wait the way Professor was saying, because India is now becoming a capital exporter rather than importer. Maybe the years are bound to come.
But still,
I would not fully agree with the judge. I can take the liberty. Yes, there are some egregious acts. Sorry. There are some egregious acts, but I think the majority are not. I think they're just badly defended in terms of material. So I think, you know, that wide paintbrush that everything the government does in every field is egregious may not be correct. There are egregious acts, and there are awards which are absolutely justified.
You are 99% with me.
interpretation.
That's good enough.
See, another problem arises because of interpretation.
Correct.
Our courts have interpreted Telegraph Act, where the expression is that the government has the privilege to grant a license. So courts have said that privilege doesn't enable anybody to virtually file a writ and say that I have not been granted a license.
No vested right.
So large number of decisions are there of this court. Such writs are not maintainable, and in any event it's not a case for specific performance. But in Antariksh case, there was no license granted. The judgments of the Supreme Court directly were on the point, saying that a court can't direct grant of a license in view of the specific expression that it's only a privilege. But that interpretation need not be accepted by them. That's another difficulty which our friends have flagged with respect to the international tribunals, going not only against the statutory regime but also against the decisions of the court which have ruled on the subject.
2016 BIT takes care of that.
With that, sorry, one last question, please.
Last question. There's one more session.
Debate, except for the end where Professor Jones came in favor of BITs. There was harsh criticism of these wretched investor tribunals that even criticize our Supreme Court. In that context, I just want to read from the Cairn Award. The respondent, India, has criticized the Supreme Court's decision in Vodafone, which it describes as poorly reasoned and contrary to the administrative, judicial, and legislative practice predating the decision. It argues in particular that the Supreme Court should have interpreted the section 911 purposively. The tribunal's response to that was, it would be an extraordinary step indeed for this tribunal not to give the judgment of the Supreme Court the weight that it commands. Even if the tribunal took a different view of section 911 than the court, it would approach any suggestion that it should embrace the respondent's criticisms of its own Supreme Court judgment with great care. Tribunals have been rather fair. Jurisdictional challenges are such a high threshold, it's very rare that you even get a chance to argue on the merits. I just felt it was a bit one-sided.
I'll respond to that. You are absolutely right. There are tribunals that are fair and there are awards that are fair. The question is which are those awards which you think are fair and which are those awards which you think are not fair. So I wouldn't say it's one-sided. Of course there are awards, including the one you mentioned, that are possibly the correct award. I mean, it quite
you mentioned about Devas. I just want to bring to your notice that the Devas, I don't need it.
Yeah, she doesn't need it.
Devas award had a tribunal which had a retired Supreme Court judge.
I don't want to.
Just brushing aside without
You see, the point is not the composition of the tribunal. It's the content. It is the reasoning in the award. That's the question.
With that,
I am Farishti
with
Setna. I just wanted to ask one question of the panel. Given the anti-BIT position
It's not
that
really anti-BIT.
seems to have come through. That seems to have come through.
That's
Pardon
the
me if I got
government
it wrong.
position. That's not the general.
way
That's the
forward.
government position.
can we
Right.
take this last
The
question
government
offline, please?
Right, but more importantly, the fact is that India, rightly or wrongly, rolled out an alternative in the form of the 2016 model BIT.
You're right.
Right.
Now, what is the intended function of that BIT if it is not actually intended to take effect, number one? And number two, in Article 15, specifically of the model BIT, what is it that the government is seeking to hold out to the world at large when it says that you will have to exhaust local remedies before you actively go out to seek remedies in the international world?
Very fortunately for us, none of us on the panel represent the government. So you have
I
raised a
thought,
very-
Mr. Banerjee, you
No,
did, but
no, not at all. I'm appearing for investors also.
I recall you in the Vedanta case in Singapore. Am I wrong
But
in that?
that was a different. That's a different tribunal. At a different-
Thank you so much. With
No,
that,
what
we
you're
come
saying
to
is
the.
right. The only thing is the search is for a better system. That's all. Nothing.
With that, thank you so much, sir. With that, we
you.
come to the end of a fantabulous session with the panelists' excellent expositions on these contentious issues, if I may add. We thank each and every panelist for their valuable sessions. And just to update Professor Doug Jones, as he had mentioned from the dais, so the current Indian score is 262 for 9 against Australia's 263. So that should bring a cheer on your face.
Let's come. Thank you very much. Thank you, everybody.